to post to share with folks when it's over. So thank you, Amber. Go ahead and get started.
Thank you, Juliet, and thank you all for joining us this afternoon. As Juliet said, my name is Amber Lueken-Barwick, and I am a resource prosecutor. I've been at the conference for 14 years now, and before that I started out as a DA in Charlotte and did mostly domestic violence cases, and then went to DeKalb County near Atlanta and did domestic violence, high-profile domestic violence cases there as well. So I've spent my career working on, working with special victims, and it has been a very rewarding career at that. I've enjoyed it very much. So again, thanks for being here. This is a topic that I get asked to speak on every once in a while, quite often for certainly for prosecutors. But like many topics, I think many of the things that are important for prosecutors to know are equally important for law enforcement investigators, detectives, everyone else to know. We can't build a good case unless we do it together. And so I hope that this kind of gives you a window into how we would work a case, how we would develop a case either for plea or for trial, but most of this is going to be really specific to how we would prepare for trial, and what it is that we hope for and need from investigators on these kinds of cases. I've been working with the SACI group for some time, and it is not lost on me that some of the very things that our frontline prosecutors that do day in, day out sexual assault cases, those are the same things that are important to those of you that are working on cold cases. You may not be able to do some of these things because you're not the first person investigating the case and you're not able to get some of this information, but working on these things, working on these cases with this in mind might help you identify details that are important, that can help us build that case and establish that level of credibility we need at trial if we're able to get there. So we'll go ahead and get started here. I'm not saying anything that new when I say that the best investigations provide these three things: a focus on the offender as opposed to a focus on the victim, what the victim or survivor did or did not do. It is the offender, the defendant, who chose to do the crime. It is the offender who picked the time, the place, the people that were around to witness or more often not witness. And so it makes complete sense that we should focus our attention on the offender and his or her actions. We should find corroboration wherever and whenever we can. And I don't mean, looking for the smoking gun here. I mean, every little bit of corroboration helps. Every small detail helps build the case and build that credibility when we look at the end of this and we look at our jurors and what it is they need to sort of look at and hang their hat on a guilty plea. And we'll talk a lot about that in detail today. And then documentation. This is probably one of the most annoying things that law enforcement officers have to deal with. I get it. Writing it down, documenting it is just not the fun part of your day. I get that, but it is the most important thing for a prosecutor. Number one, it gives us an idea of what we have to work with from the beginning. We get this pile of paperwork. Oftentimes you'll come in and we'll talk about it, but if it's not written down, it may not as well have happened, at least with respect to how a defense attorney is going to portray it later on. And so we need that all to be documented, and we're going to spend a good amount of time talking about that as well. I'm sort of starting this from the end. I'm starting this from the point of, what do we know is going to happen at trial? What do we know from experience, from history? What can we learn from that? We know that by far the most common defense is the consent defense. And all of these things are sort of tangentially related to that, right? Like, you know, there's the straight up, no, she said yes, actual consent, and that's what I'm sticking with. There's a, well, I was pretty sure she was into it, you know, the mistake of fact. There's alcohol. Either the defendant is saying that he was too impaired to understand that she was saying no and is using that as some sort of defense, or the defendant is saying that the victim doesn't recall because of certain levels of impairment that she, you know, willfully or not induced or ingested. So those are just all sort of tangentially related to what is one larger defense of the consent defense. And then there's just sort of the smoke and mirrors that get thrown in there related to all of them, which is just the categorized, large category I'll call inconsistent victim behavior. And from the point of the jury, all of these things are things they are going to have to contend with. And they're hearing it from a defense attorney and they're hearing it from a defendant. And it's unfortunately already something that's out there in the general discourse of everyday life. All of these things, all of these notions, whether we're conscious of these biases, whether we're conscious of how we think a victim should react, they're there. And we have to be ready for them as prosecutors and as investigators. We have to know at the beginning that this is what we will face, despite everything we know, despite all the years of enlightenment, the Me Too movement, the, you know, all kinds of things that have been very positive on the front of sexual assault investigations and prosecutions. We still have to be ready for that jury who has outdated and just completely wrong notions of what sexual assault looks like. And so that's where we start. We start from the end, really, from what would be in this long process, the very final part, the trial. Getting ready for what it is those jurors and that defense attorney or defendant are going to be thinking and saying. So what do our jurors think, and why do I know this? From years and years of you know, prosecutors handling cases like this and getting these responses when they go and talk to jurors afterwards. You know, hey, he looks like a good guy, man. He looks like he'd be my neighbor. You know, maybe this was some kind of misunderstanding. It is so much easier for people to believe that it was a mistake, that it was a misunderstanding. That's what we want to believe. It is easier for people to think that and want that to be the case. And sometimes they're looking for that, something that they can, you know, use to believe that it was a mistake, so that, you know, they don't have to feel so bad about something like this happening. She was so drunk, it's no wonder he couldn't tell what she wanted. Why, you know, where did she say no? Why didn't she say no? And then, you know, delayed disclosure. Why wouldn't she tell anybody right away? Why did it take her 2 days or 3 days or whatever to tell somebody what had happened to her? And then I wouldn't have done that. Putting yourself, and the jurors do this, even despite every sort of, you know, jury instruction, them saying, I would never have gone to that party. I would never have gone into that room. I would never have done that. Those are the things we're thinking about, and we have to combat from the beginning. So what do we want them to be saying instead? We get to control this. We get to control the narrative and frame this issue. So we want them to be saying, you know what, this isn't about the no, it's the yes. There was no yes ever. She never said yes to this. And there was no reason that he or she should have thought that was the case. There's no reasonable proof, no reasonable evidence that she ever indicated she consented. And she in terms of why didn't she report right away? We want the jurors to be thinking, well, she told people when she could. She told people when she felt like she could and when she felt she was safe. And we'll talk about a few ways that we can kind of document that kind of that evidence. We want them finally to be thinking he knew what he was doing. He knew that this was his moment. He was in control of it. He prepared, he planned, and he executed. That's what we want them to be thinking. Every one of those every one of them is thinking more of the offender and the offender's focus, and not so much blaming the victim. And that's exactly how we need our juries to be thinking about this at the end. Now, as a prosecutor, that's what pretty much what my closing argument needs to sound like, and what I want it to sound like. But I need to be able to develop that in the course of the trial to be able to argue that. And so we'll talk about what sorts of evidence as a prosecutor, I need to help me get there, to help me get the jury there with me, so that by the end of this, they're thinking, yes, he did this and he knew what he was doing. Quickly, just a word about consent. It seems like such a simple notion, right? But in terms of the law, we must prove. Or nobody really has to prove anything, really, other than there wasn't consent. But consent we think of as it being an informed, a voluntary, and a mutual decision, right? So it's not, it's not really that fuzzy. It doesn't need to be that fuzzy. That's the kind of thing that the defense attorney might be throwing out there, that it was unclear, it wasn't, who knew, who knows, no words were said. Consent is consent. We don't need to make it any harder than it really is. Only last year did North Carolina pass a law that allows victims to withdraw consent. So none of the cases of, in our cold case piles will be able to use this, but going forward, we'll be able to charge more cases where victims may have initially consented to a sexual encounter, but then withdrew that consent, and therefore, turning that into a crime. So that's something that took a long time, but I'm very thankful and very happy that we have that extra tool in our toolbox. We also need to remember of consent, and this is almost the easier part, the sort of strict liability section of this, which is that it can't be given. There is no way to consent in certain instances. Maybe it's because of the age of the victim or the mental incapacity, the physical helplessness of the victim. And we're not going to go into each particular crime in this session in sort of the elements of each, but certainly you all are familiar with those. And if you're not, or want to discuss any particular case in detail, I'm available. My information will be at the end of this presentation. I didn't say it, but if you had any questions, I can't see your all of your faces or know whether any of you are raising your hand, so I'll do my best to kind of stop periodically, and you can certainly use the chat feature as well if that is helpful to you all. Okay, so framing the issue, much like framing the issue, we want to frame the investigation. Setting the investigation up from the beginning to focus on our offender, whether known or unknown, focusing on the actions of the offender are important. They're going to help us build that case towards the end to attack any sort of consent defense, any one of those varieties of the consent defense that may be presented. And keep in mind, if we do this right, we will be potentially pigeonholing the defendant into a particular kind of consent defense. And this is not an unknown tactic, but tying the defendant in or tying the defendant down to his or her version early on is going to prevent some of the other tactics or some of the other types of defenses that they may try to use later on when they're presented with other evidence that says, yeah, you know what, that doesn't make sense. What you just said, what you initially said can't be how this happened. So that's why sort of tying them in or boxing them in to that version or whatever that version is at the beginning is incredibly helpful at sort of attacking the credibility of the offender and the offender's version of events later on. A word of caution, we're going to talk about questions and topics and things that you should and shouldn't discuss with the victim, ways you shouldn't and should not say them. This is not a comprehensive presentation about how to use the trauma-informed interviewing techniques. I encourage all of you, if you've not already had trauma-informed interviewing training, to get that. I'm certain that there's plenty of that available through the SACI program, and if not, and I know that the bits and pieces of it come into a lot of training, but some very specific training on how to talk with and interview a victim is essential for asking the right questions and getting the answers that we can use. And also just for your general information, your general knowledge. It is so helpful to understand why a victim may answer something the way that she or he does, or why they may not be able to answer something at a particular time, just based on the scientific reaction, the brain's scientific response to traumatic and fearful events. So I caution you, we are not going to go into that in depth, but each of these steps needs to be used and taken with that trauma-informed approach. One of the things that an offender will be quick to point out is that, well, we knew each other, you know, we were dating, you know, and one of the things you really need to flesh out is, well, do they both agree on that? What exactly do each of them think is their relationship? So asking each of them separately, obviously, in the course of your investigation, you know, what was your actual prior relationship? And then what was the context of this particular encounter? You may get completely different answers. You might get an answer from the victim that is something like, well, I think I've seen him in my class. I mean, I think I might have, you know, class with him. Or maybe he goes to my gym. I think he goes to my gym. But if you ask the offender, you know, they go to the gym together. They're friends. They talk. They, you know, whatever. So that right there, documenting that the difference in what each of them perceives as the relationship is very essential, because it obviously goes a long way towards what makes sense when later on an offender is claiming that a sexual encounter was consensual if the victim isn't even sure that he does or does not go to the same gym.
Hey, Amber.
Yes.
I'm just going to hop in. One of the comments in the chat was, what classes do you recommend for trauma-informed interviewing? And I wanted to certainly hear from you, Amber, but wanted to let folks know that we are, this is, you know, one of many lunch and learns. We have 7 additional ones coming up, and we are going to be doing one on exactly that, trauma-informed interviewing. So definitely look forward to that. And then I know End Violence Against Women International has a lot on their website. When this session is over, I'll send you an evaluation. And Amber, I forgot to ask, are you able to share your slides?
I am happy to do that. Absolutely. I'll share them. I'll send them to you, and you, yep.
Perfect. So we can share the slides, and I'll add some additional training resources in that email. But if you have others, Amber, also please share.
No, that sounds wonderful. I think that, you know, the lunch and learn will be wonderful. There, depending on your specific discipline, you may be able to find, you know, like specific law enforcement tactics, or, but I'll say, like, the best for me was to hear from medical professionals, like a SANE, and also I think a neuroscientist at some point. I just sort of listened in on that, but that may be a little more than what you need for just sort of the day in, day out, how do I ask the right questions and how do I understand the victim. But I think what Juliet just mentioned will be just perfect for that. All right. Asking the victim in along the same lines of sort of framing what their relationship was with respect to, you know, whether it even makes any sense for this to be consensual. Asking the victim, you know, what part of this, if any of it, did you agree to? Because sometimes, you know, as we know, the vast majority of sexual assaults are not stranger cases, and there are different levels of what that means, you know, from the we had a dating relationship, and this particular night, it was not consensual, to we're on our first date. We'd been talking over the phone or over over an app, dating app, and this was our first physical encounter. So getting an idea from the victim of what her expectations of this particular encounter were. Now, I've certainly had cases, and I'm sure you have too, that even by the victims, this can be tricky for a victim to be upfront with. So the most important thing we can do is to be non-judgmental. I've certainly had victims that have said, I was okay with oral sex, but I was not okay with anything else. And it turned into a vaginal rape situation. So being very cautious of how you ask the questions, obviously, getting to the heart of what did she expect? What was she okay with? What was she not okay with? And then asking, when did you know that something else was going to happen? When did you realize that you were in danger? That's a pretty good question right there, because it, they may not even say that they knew they were in danger yet. They may not realize, but most of them are going to think of, it's going to trigger a moment where they thought, oh crap, this isn't happening. I can't believe this is happening. And in the trauma, in the trauma informed response to that, almost 100% of the time is going to be one of those three things that we've probably heard before: fight or flight or freeze. And so knowing that that question may guide you towards a particular type of response that your victim had in that situation will help you document and help you know sort of which way to go, which questions to ask. But you'll learn from those kinds of trainings that the more experiences you can call out, the more you can focus on the experience, the feelings, the emotions, what she was thinking, smelling, seeing, any of those things during the time will help you document those things, and may also help her recall things. So asking, what were you thinking? Were you able to say anything? Were you able to do anything? Helping her sort of hone in on those types of things. But again, I'm saying these in a way that may not be the best way for you to actually ask the question. In court, I can't be leading at all. I could not say, were you able to do anything? Were you able to say anything? I would have to say, what, if anything, were you able to say? Implying that there is the possibility that you weren't able to say anything. We never want to make them feel or think that they should have done something or should have said something. So how we're asking that question is important in going forward. And if anybody has any questions, please let me know. And in turn, talking to the offender, asking the offender, what did the victim agree to? Asking him, well, what did you talk about prior to meeting? What is it that you thought was going to happen? Did you agree to meet at the movies? Did you agree to go to dinner? Did you agree to one drink? Getting sort of concessions. There's going to be very likely some portion of the versions that are identical. Sometimes a lot of the versions are identical. And so agreeing, getting even the offender to agree to what it is the victim agreed to, or getting them to sort of own up. Well, yes, we agreed that we would go see a movie, or we agreed that she would come to my house and see a movie. Those kinds of things. What kind of discussions happened before? And then asking, well, what happened before the crime? What if anything was she saying during it? What was she saying after it? Of course, you're not going to call it a crime when you're talking to the offender. You're going to use whatever phrase works for the scenario. But in the way that I know you investigators are trained and skilled at doing, getting the details and the concessions that they're willing to give, and sometimes more than willing, happy to give you, because they think it's helping them. And then documenting those is essential for tying this in at the end and painting a picture of whose version makes the most sense given all of the pieces to this puzzle. Alcohol. So that was sort of just a rough sketch of, get on paper what everybody thought was about to happen, what everybody thought was their relationship, what each party thought was going to happen, and sort of get that out there to begin with. In terms of alcohol, what are our most common, what do we know about it? It is by far the most common drug used to facilitate sexual assault. A fantastic prosecutor said long ago, who needs a gun when you've got alcohol? It is the most it is present in most cases, unfortunately, and that makes it difficult not only for the victim but also for the jury, right? Because the jury understands alcohol, they've had experience with it, and they may have had good experiences with it, and they may have had bad experiences with it, but at any rate, they have an opinion, for sure, about alcohol, and so it's something that we need to be ready for and thinking about. We need to focus in terms on the victim and how alcohol affects her vulnerability, not her culpability. It is not a crime, unless you're not of age, to partake in drinking alcohol. That is not the crime. And so demonizing a victim because she chose to go to a party and because she chose to have a couple of drinks does not make sense. And we need to make the focus different. And I say this, and when I say we, I mean me as well. We all need to be thinking about this, not from the, oh crap, she was drinking, kind of standpoint. No, we need to be looking at that as an area of vulnerability. And again, this is part of, very often you can make this part of your case or part of your argument, that the defendant knew exactly what he was doing. He understood that this was making the victim more vulnerable, and in many ways it was him that sort of encouraged, if not completely facilitated, this happening. We also need to make sure we're aware of the different levels of intoxication. Like, we can't just say she was drinking, she was, we need to be really clear, and we'll go through some questions about what type of impairment we're talking about here, because as we know from the law, there are different legal avenues that we'll take in charging, and so we need to be documenting those things. It also helps us lay the foundation for showing and arguing what the defendant knew or should have known about the victim at the time. So we know, as I said, in our law, that there's impaired, there's a level of impairness, but then more importantly, there's a level of physical helplessness, which is unconsciousness, basically, or a level of mental incapacity. And as I mentioned, earlier in the same piece of legislation that introduced the ability to withdraw consent to a sexual act in North Carolina, we tweaked our definition of mental incapacity. Super important piece that was missing. Previously, mental incapacity was not even available. I couldn't even pursue that line of legal theory under second-degree rape, or second-degree sexual assault, for that matter, if the victim had voluntarily become intoxicated or taken substances, and become impaired on her own volition, basically. But last year that changed. It is not to say that before last year I could not have pursued charges, but this now is one more avenue to pursue in terms of second-degree rape and sexual assault. So the levels of impairment, what kinds of how much they had, when they, all of these things on this screen are important for us to know. And again, I can't stress this enough. I'm not phrasing these in the way that you may need to actually ask the question if it's not the most sensitive way to ask it in your particular case. Depending on the trauma, depending on what's happening with the victim and your level of comfort and their level of comfort with you, you may have to be careful about the way that you ask these questions. We never want to imply that there was a right or a wrong way to have done this. There was a right or a wrong way to have handled the situation. And so, but understanding it and documenting it will be important going forward. Whose idea was it to have drinks? Was it the offender that was pouring the drinks, serving the drinks, telling her, you need to try this? Isn't this great? Let's do shots. Were you comfortable with it? For a lot of victims, this may, the alcohol is the very thing that is helping them be comfortable with a new date or a new situation, and they're trying to fit in, especially in our college campus situations. So working out with them, what their level of comfort with drinking is to begin with is important. When establishing a time frame, when did you start drinking? How long were you drinking before, the sexual assault began, before he started to try to, pull your pants down? Whatever the situation was, try to establish that time frame. These are not always, again, because of trauma, these may not be details that they have. And so knowing that you may not get an answer or that they may not recall is okay too. Just make sure you're cautious of how you're asking those particular questions. If they know how much he was drinking, ask those kinds of questions, or what he was drinking as well. Ask, that's great. It may be, that he was pouring her, 3 shots to his 1 shot, and that we can make a pretty good argument that it was premeditated. What he was doing and what happened was premeditated. If that may be the situation. Ask how you were feeling. Ask how were you exhibiting that? If she's laying on the couch, practically unconscious, or trying to go to sleep in a chair, then that's something observable to the offender. And so if she can tell you and you can document what she was feeling, what she was doing, that will become super important if his story is contradictory. Similarly, ask the offender. You may get the same answers. There may be some consistency here, but there may be some inconsistency here too. Whose idea was it to have drinks? He may voluntarily, say it was mine. I was, I was pouring drinks, whatever. He may say, I don't know, I think she had a couple before she came over. Well, if that's consistent or inconsistent with what she said, then we can, we look further for any other proof of that. What made him think that? What proof, where was she before that? Are there any witnesses that can contradict that or not? Talking about what did he know of what she had to drink and how much. His level of knowledge of what she was doing goes to his state of mind. If he knows that she has already drank way more than any person should possibly have and still be standing up, and yet he still is going to stand there and argue that she was totally into it, said, yes, let's do this. It makes no sense. And it helps me argue that very same thing in closing. So kind of getting that baseline of what he thinks of her and what he knows of how much she did or did not drink and what it was she was drinking, and certainly a time frame as well. This is one of those areas where he may answer quite honestly and willingly, not really understanding the full effect of it. As I said, if he, says, yeah, she was passed out on the bathroom floor, but then 5 minutes later she was ready to have sex, that doesn't make any sense. But he may or may not know the way that is going to be presented, or way that is going to sound. Victim behavior, here's what we know is coming our way, right? We know that they're going to attack every single little thing that the victim did or didn't do. And sometimes it's completely, you're damned if you do, damned if you don't. These poor victims. On the one hand, they'll be attacked for remembering everything in way too much detail, making it sound as if they've had time to think about it and it was plotted and everything down to the last detail. But then if there's any little bit of inconsistency, well, then they're making that up too, because they've got to be lying, because they're look at how different these two versions are. So they're damned if they do, damned if they don't. So from our own perspective, getting rid of all our own biases of what we thought was truthful, was evidence of truth and credibility, and what we now know is probably the effects of trauma on a victim. Those are the things, that's what we use. That's how we question our victim. That is how we think about our investigation and how we think about our charges. And I know from my own perspective, I am preparing for that line of questioning, that line of cross-examination from the very minute I get that case on my desk. And so that means I might be thinking about expert witnesses that can explain trauma, but it also means I'm going to be making sure that you as a detective are able to describe exactly what you observed and exactly what and why you did certain things. Obviously, the effects of alcohol will come into play, and we'll have to discuss those and make sure that we're not using outdated and just plain wrong facts and notions about that. But then other just more widely held misconceptions about sexual assault victims, and we'll sort of take these separately. We know that that victims will be attacked for these various things, right? These are misconceptions. Delayed. We know this happens in sexual assault. We are not surprised by this happening in sexual assault cases or domestic violence cases for that matter either. Delayed disclosure, fragmented recall of events, memories, and details, a lack of injury, and other unexpected responses, right? As if there is some playbook by which victims should respond, should react, should act after they have been sexually assaulted. The contrary is what we should be expecting. There is no known notion of what you should or should not do after this, and we need to get that out of our vocabulary. We need to make sure that our jurors understand that that's just not the way this is. So when we're ready when we're presenting this to the jury, here's what we're hearing. She delayed because she was having second thoughts. She regretted it. She made this up. As a prosecutor, as a law enforcement officer, we need to be laying the groundwork for the logical argument, which is she delayed because she was still scared, because she could not believe that this person that she had gone on a date with, that she thought she knew, would do this to her. She delayed because the trauma itself was preventing her from doing anything. The defense may argue she keeps adding details to bolster her credibility and embellish. This is one that for years was, that if you look back at your reports now, especially some of these cold cases, this is going to be something that detectives wrote in there. I know this because I read old files, from very good, and even notes from prosecutors, very good prosecutors. But this was a way of thinking that is wrong, and our experience with trauma and the science of trauma bears that out. The fact that pieces come back bit by bit, that's the result of trauma. That's not a victim trying to bolster. That's not a victim trying to make her story sound better, more credible as time goes by. That is how trauma releases. That is how trauma affects a victim. Their memory has not coded those details like a normal event, like a joyful event gets coded in your brain. It is scrambled. It is sometimes not even coded at all. But when and if they can recover any of those pieces, they will come out fragmented. They will come out maybe not even in a sequential manner. But at any rate, that explains it. In fact, not only does it explain it, but it lends credibility to the victim. it makes it more likely than not that she did suffer a sexual assault because we have evidence of trauma here. So we can use it both ways. Not only does the trauma explain why the details are coming out this way, but the trauma itself and the details coming out like this are evidence that it actually happened.
Hey, Amber.
Yes.
We have a question from Laura Kensington that says, often I will ask the victim why they delayed reporting the incident in a very tactful way. Should this be a question I should continue to ask because I know the defense will ask it, or should I stop asking that?
I think we definitely want to know everything, right? I never want to be surprised. I never want the defense attorney to be the first one asking a question. So yes, we want to ask that question. We want to understand it, but how you ask it is really going to be a case by case decision. You know, like it may not. I don't think it's the first thing you want to ask in your initial interview, but I think it's something that you're going to want to get explained eventually. And sometimes if it hasn't been asked by a detective yet, as a prosecutor, I'll ask the question, but I'll say, it's part of my conversation that is, here's what I think's gonna be an issue. Here's what I think they're gonna try to make a big deal out of. You didn't call the police for 2 days. Why not? Can we just talk about that so I know why, so that I can help, explain that. Ways that kind of open it up to, there is no wrong answer here. I just need to know so that I can be ready for trial, so to speak. Those are the ways.
I think sorry, that's super helpful. And Laura had a follow-up question that I think you answered somewhat, but will the DA call a trauma expert to testify to this lack of details piece by piece, or will I have to testify as a law enforcement officer to this?
Great question. And I will say, and I may say this if I forget later on, it is something, if it depends, I guess, it is not easy to find somebody that, and it is very difficult to do that in every single case, right? To get a trauma expert. If you as a investigator are trained, I'm going to ask you that you're going to be the person. And so when we talk about later on in the, if we have time and we get there, I'm kind of feeling we're a little bit, we'll have to pick up speed here, but in your documentation, I want to know based on I want you to write that kind of thing based on my experience with sexual assault victims, and I don't want you to go overboard with it. I don't need you to, write an expert's opinion in your document, but I'm going to ask you. And if I feel as a prosecutor that you know enough and have experienced enough about that, then I'm going to figure out a way to sort of make you my expert. I may not qualify you technically as an expert, but your own expertise, your own experience, just like a saying, gives you that credibility and gives you allows you to answer some of those questions. So if it depends on the case, I may need to try to call an expert though.
I think that's very, very helpful. And she has one last part. They're all really great questions that folks are asked, probably want to know. So thank you for answering them, Amber. So Laura says, so do you think in the main interview that I do with the victim, which is usually around 4 hours long, I ask about the delay in reporting, or should I hold that until we meet with the DA? Obviously, these interviews are recorded.
Yeah, I don't think, I think you need to take that one in the moment. Like, how does your victim feel? How is your victim responding, and are they, do you have a good enough rapport, or do you feel like it may do more harm than good in that moment? That's really a case by case, but just know that your DA needs to know that later too. So they will ask that question, they will follow up. If it is something that you feel, if you're just not sure of, I'd say wait and sort of ask it later. Okay, we'll move on. One of the other things, and you can read these as well as I can, we need to be able, the jury's going to be presented with an argument that there was no injury. Well, we need to be able to say that most don't have physical injury. And so that might be something, again, like trauma, that, experienced investigator or sane will be able to talk about for sure. And then talking about what the reasons why somebody might not fight back in the way that somebody might, in the way that might conventionally be thought of, is that was really the brain's response to this traumatic event. Not just fight or flight, but freezing is one of the other responses that science has shown to be used by victims of traumatic events. All right, so in general, and again, we need days, if not, we need hours at the very least to talk about a detailed trauma-informed interviewing experience. But questioning the victim about what they experienced with their senses. What did you feel? What did you smell? And again, this seems odd, but we'll talk about corroboration in a bit. So that's why these things are important. It also helps them to trigger other memories. If they think about a smell, or they think about something they heard, it may trigger something else that was happening that is important for one of the elements of our crime. If nothing else, asking it in this way is low pressure. What are you able to remember about X? What are you able to remember about, how you got into that bedroom? What are you able to remember about what he said to you? What are you able to remember about anything you might have said? It lowers the temperature, right? It implies that you may not be able to remember anything right now, and that's okay. But if you are, I'd like to hear about it. That's how it sort of helps the victim understand there is an opportunity here to not remember, and that's okay too. It doesn't mean that this person won't believe me. They understand that I might not remember it. But again, it might help them. It may trigger something as well in their recall if they're able to think about a sense or an experience that they had, a sensory experience. And as I said, every little thing counts. So they remember they smell, smoke on the defendant as he was on top of them, right? They smelled that cigarette smoke on his clothing. That's an important small piece. Is the fact that the offender smoking one of the criminal elements that I need to prove beyond a reasonable doubt? Absolutely not. But if I have that in my documentation, and I also have that the offender, who, let's say she doesn't know, this is a non-stranger offender, let's say that law enforcement are investigating and interrogating this suspect, this particular offender, and he needs to take 3 smoke breaks during the course of a 2-hour interrogation. Those little things together add up. They corroborate. All the little tiny pieces mean something in the bigger picture. They help that jury visualize something that they can't see. There's no body cam of this, of what actually happened, of the crime itself. But it helps them visualize and put together these pieces. And at the end of the day, it says, you know what? He's definitely a smoker and she smelled that smoke. That's one little thing. And every little piece builds her credibility. And it also empowers the victim. It helps her or him understand that whatever I can remember can be important. And so building that foundation and building every little tiny bit of evidence is important. Does it matter at the end of the day? Do I need to prove beyond a reasonable doubt that the defender had a green plaid shirt on? No. But if she remembers that green plaid shirt while he, because that's the only thing she could focus on while he was raping her, and then the detectives find him with a green plaid shirt on 2 days later, or find it in his closet, that it doesn't mean he did or didn't do it, right? But it's a piece of evidence that lends to her credibility. And so that kind of corroboration is super, super important for our jurors. Same with witnesses, other witnesses, like, witness and victim together, like who saw the victim afterwards? Like what was her demeanor? What did she do? What did she say before, after? Setting the stage for the event itself before, and then what happened afterwards. Were there other witnesses that observed their levels of intoxication that can either, bolster or her version of there's no way I was, I was laying down on the bed. Did somebody else see that level of intoxication of her? All of these things, talking to witnesses can help you help verify, corroboration, bit by bit. Did her best friend see her, curled up in a ball in the corner of the room? That's evidence of trauma. Things like that can help you, that help make what the victim is saying more likely than not. All of these things, I'm picking up speed here just because I think most of us know the importance of these in an investigation. But the physical evidence, medical evidence, the absence or presence of an injury, again, we may need an expert. A SANE could talk about the value of that and the significance of that. Looking for other types of evidence to sort of corroborate it, where there are text messages that say, yeah, I'll meet you for, let's meet at the theater, we'll see this movie. That sort of establishes, yeah, well, I thought we were just going to see a movie and that was it. Things like that can sort of lend credibility to the details that she's able to recall, painting a picture that what she is saying is more likely than not the way things happened. Documentation. This is my, I believe, final large sort of piece of the puzzle. Everything we just talked about, I need it to be in the report. As I said, as far as defense attorneys are concerned, and maybe even some jurors, unfortunately, if it's not written down, it didn't happen. And they're going to hammer a victim or you as a detective if you haven't documented it somewhere. And so the way you write it and the fact that you write it are equally important, right? Use the words the victim gave you. Don't summarize it. Don't turn it into, a shorthand version of what the victim said. I know it's not fun to do these reports. And now with body cam, a lot of times you may not fully have to do it, but in the report, document with her own words. Don't clean it up. If she curses, if she's, she uses language that the defendant used and it was curse words, use that language. Document what you're seeing of her, your own initial objective observations of the victim. Is she shaking? Is her leg moving up and down? Is she unable to make eye contact? If a door opens, does she jump slightly? All of those little things that may document or be indicative of fear, of trauma, and of triggers for her, things like that. Making sure you're documenting all of those things and her responses as well. Describe what, if you can, in your what did force look like for the victim? Force is not what jurors think it is, right? We know that force does not have to be a weapon pointed at the side of your head. Force is all it needs to be. Think about your own experience as law enforcement officers. Sometimes mere presence is enough for compliance. For this victim, what was it that made her believe that she had no other choice? What was it that made her believe that this was going to happen, and her whatever response, whatever traumatic response she had kicked in? Careful with the words that you use. Again, we're looking at this from the very end point here. And if we know that they're going to try to say this was consensual, we need to be careful with our words, right? Do not use words that imply consent. If she tells you, that, and this is for the prosecutors too, if there's prosecutors on the call, as hard as it is for your victim to testify, we cannot just summarize it by saying, and then he had sex with you, and then he forced his penis into her vagina. If that is what happened, those are the words that need to be in the report. It's too easy for a defense attorney to read that and start thinking that was some sort of consensual, that consensually they had sex, right? he took her into the bedroom versus they went into the bedroom. One implies he was in control and exerting control. The other implies it was consensual. So use the correct words. Don't make them up. I'm not suggesting you use improper words, but don't use words with an unintended consequence, right? Use the right words. Use the words that describe what it is she is saying happened. Use her words. And then document everything.
Hey, Amber, we've got another question. I know we've got 3 minutes left. So would you prefer to, do you have like some last points you'd rather state and maybe answer the question over email, or do you want me to?
You know what, I don't think I have much left. I don't even need to, we'll get to questions. Give me
Sure.
Yeah, sure. You could, this slide is self-explanatory, making sure that we're writing down everything, that we're showing the evidence, that we're documenting everything that demonstrates that the defendant was cognitively able and to understand what was happening if he is claiming that he was too impaired, and then all evidence that it was not at all a misunderstanding. And this is where the question earlier came in am I going to be your expert or is somebody else going to be your expert? You guys know a lot of stuff. You know why you do multiple interviews. You do multiple interviews because you know that a victim can't recall everything at once. And now you know it's because of trauma. It's not because you're giving them a chance to better their story, to fix it up, to pretty up. It's because they will recall things at different times. That's why you do multiple interviews. So make sure you're documenting why you're doing what you're doing, so that you remember it and that I can use it in the course of the case. And I'm open for questions. I've left 2 minutes, but I'm not going anywhere if anybody wants to stick around for a while. I'm ready, Juliet.
All right. So the question is, how do you feel about getting a victim urinalysis if she was intoxicated during the rape and immediately reported it? I have mixed opinions on this technique. The purpose would be to determine the blood alcohol content of the victim. I've seen this backfire, and the defense was happy to say she wasn't drunk enough at 0.03. I'm sure we could do analysis on the alcohol metabolizing based on how many hours since she drank to reporting time, etc. But I'm not sure we should do this.
Here's the thing. The evidence is the evidence. We take them as we get them. We don't get to, if the investigation directs you in that way, then you get it. If the victim is able and willing to provide it, you can get it. If your evidence and your it doesn't lead you there, then you don't have to get it, I would say. But I would never say don't do it because you're afraid it might backfire. I will promise you that I will have to deal with far worse than that in most cases, and it's okay because we don't get to set the facts, right? We accept them as they come to us, and we understand. There is no level of intoxication that means I can or cannot prosecute a case. It's just different theories. It's just different theories and different ways of proving what it is the defendant did and what level of knowledge he may have had. Any other questions?
Okay, we have another response. It says, okay, so there's two. So there, in response to you, Amber, she says, so should we be doing this as a standard practice?
Getting a urinalysis? I can't say that. That isn't something I'm able to say. I don't think that every single case warrants that at all. I think, in fact, it might be the outlier that warrants that.
Okay. And then somebody else responded, just a thought to that question. Maybe it's possible that even if your BAC was high enough, just like a DWI case, you can articulate impairment outside of the final numbers, so to speak.
Yeah, I agree with that. There is nothing about a victim's BAC that should either prevent or allow, I guess, a prosecution to go forward. I don't have that information on the vast majority of cases. It's not an element. I don't need that. That is not something. I'm far more concerned about other observable things that are happening, right? I don't, and we can put an expert on the stand that can extrapolate somebody's alcohol. That isn't where I want to go, I'll be honest with you, with a trial, because that's exactly the kind of thing that turns this into a focusing on the victim as opposed to focusing on the offender. I very rarely do I don't really get that very often. I don't get a BAC on a victim, and I'm okay with that. I am still perfectly okay with proceeding on that case, because it is not a crime for her to have alcohol in her system. And everything that happened with respect to the alcohol in her system is just a piece of the puzzle. It is not an element. It does not prevent me, and it should not prevent me from trying that case. So I don't want to do anything, and I would never suggest we do anything that focuses too much on a victim's perfectly lawful behavior as opposed to an offender's unlawful behavior. And I'll say this too, if you guys have specific cases that you would like to sort of talk with me about, that's why, my phone number and my email are here. I'm happy to do that. Strategizing, I find it much easier to strategize about specific cases with the, with the facts at hand. It's really hard for me to say overall, an overall approach in every case that you should do this or that. And so if you need to do that, I'm perfectly happy to do that.
Well, thank you so much, Amber, for that great presentation. I think you touched on so many questions that so many folks have. And on behalf of the North Carolina Department of Justice, we want to thank all of you for attending today. Like I said, we have additional lunch and learns coming up, and I will get you an email with some trauma-informed interviewing training options, as well as an evaluation and these slides that Amber has pulled together for us. So definitely follow up with Amber if you have questions. Amber, we're so grateful to you. It was really, really helpful. And thank you all for coming.
Thank you all.